Operations Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman Lundberg Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pooled together patent operations experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key operations challenges and issues and share best practices on how to overcome them. The Operations Excellence webinar series is free. This is the second of about 8 webinars in this series. To register for future webinars, go to the tab for Educational Resources on the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today will cover best practices and processes for managing the drafting and filing of U.S. applications. So this is really the pre-filing process, the process up to the point that the application is filed. We've allowed time for questions at the end of the webinar. Questions may be submitted using the question button on the right-hand side of your browser window. You can submit a question at any time during the presentation. The question will be held in a queue until the end of the presentation. The presenters today are myself, Brenda Foy, and John Greaves. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years. I also was a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Brenda, can you tell the audience about yourself?
Sure, thanks, Ann. Hi, everyone. My name is Brenda Foy. I am a IP paralegal at Seagate Technology. I've been in IP as a paralegal for almost 10 years. The first 8 were spent at a small patent firm, and then the last year and a half, almost 2, have been in-house at Seagate Technology. Here at Seagate, I am an IP paralegal, and I manage our patent database, which I will inform everyone now is Foundation IP, and a lot of the examples that I will give today are sort of geared that way, but I think a lot of them can be implemented in any of the docketing programs that are used. So I look forward to speaking to everyone today. Thanks.
Great. Thank you, Brenda. John, can you tell everybody about your background?
Yes, this is John. Thank you, Ann. I am a chemical engineer and worked in industry for quite a while, and then went to law school while working at the patent office. And I have had experience both in large firms and in large corporations, both as in-house and outside counsel. And most recently managed one of the largest portfolios for Intel Corporation. And at this time, I'm of counsel with Schwegman.
Great. Thank you, John. And thank you both so much for being here today to share your experiences. The topics that we'll be discussing today are generally related to drafting and filing U.S. applications. And more specifically, we'll drill down into how corporate IP departments assign and distribute disclosures to outside counsel, how the corporate IP departments track the status of applications prior to filing, and how they perform quality reviews of outside counsel's work. The process for doing each of these things tends to vary greatly from company to company. So as a result, the tasks involved are obviously typically very company specific. But because this webinar is focused on patent operations, we'll really be talking about the process aspects as much as we can of managing the drafting and filing process for U.S. applications. Some of the things that we will discuss will focus on the particular tasks that are being performed from an operations standpoint. We'll also talk about a little bit on software and systems used to manage the pre-filing process, and I know Brenda's got some great tips for any of you who use Foundation IP, but as she said, these can be applied, I think, more generally across multiple systems. And then also think a little bit about who's the right resource to manage various tasks and systems that are involved. So just to get you guys thinking from a process standpoint, I wanted to mention those things. Before we begin, though, I'd like to give a little bit of context of the audience that we have. So we have 2 polling questions that I'd like to put out. Brian, are you able to launch the first poll for us? Okay, we'll give everybody a few seconds here to answer how many U.S. patent applications your company files per year. Just looking at ranges here to get some general degrees of size. Is it typically 100 or less, 100 to 500, or more than 500, or you're not in a corporation, so it's not applicable? Giving everybody just a few more seconds to vote. All right, so most people are in the range of 100 or less. The responses were 44% 100 or less, 14% 100 to 500, and only 8% more than 500, and then 34% don't work in a corporate environment. Brian, can you launch the second poll? I have one more poll. Okay, we'll give everybody a few seconds to answer this one. Again, just for context, we'd like to know what portion of those U.S. applications are then written by outside counsel. Less than half, more than half, 100%, you don't handle any drafting internally, or again, you're not a corporation. So give everybody a few seconds on that. Okay, so the largest set of responses was less than half are drafted by outside counsel. So there's a lot of people that are doing quite a bit of drafting internally. 26% of the audience said less than half of the applications are drafted by outside counsel. 13% said more than half are drafted by outside counsel. 19% of the audience said outside counsel does everything, 100% of the drafting, and then 42% said not applicable. So the largest responses across the 2 polls were less than 100 applications filed per year and less than half drafted by outside counsel. Just helpful to know that context as we move forward here. All right, moving on. Before we drill down into specific aspects of the drafting process, I just wanted to comment at a high level what some of the typical steps are that may be implemented after a disclosure is selected for filing. So we're not talking about the selection process and the patent review committee process in this program. We did cover that in a prior webinar, which is available on our website. This is assuming now that the disclosure's been reviewed, it's been selected for filing. What happens between that point and the point in which the application is filed? Some of the typical steps are, first of all, somebody has to determine where and who to send that disclosure to. And again, these may seem simple, but there's different ways to do this. Do you have a database where you can log into that database and those disclosures are sent out through your database or your docketing system? Does somebody have to send those directly by individual emails out to outside counsel? Is there some kind of automation that's involved to make that process more efficient? Then there's typically some tracking of the deadlines for outside counsel for the pre-filing process. And I'll talk more about that in a couple of slides. That can be a very hands-off process, or for some corporations, they can be very, very hands-on in monitoring the deadlines and target dates in the pre-filing process. Then once the application has been written, many organizations have an internal review or a quality review, QR process. John's going to talk about his experience with that part of the process. And then how does the outside counsel get the filing authorization? And then how do they report the filing of the application? And then finally, tracking and billing for approval. We don't cover all of these steps in detail. I just wanted to list them out as a typical process may include various ones of these items on this list. Again, every organization's a little bit different. Some companies are very hands-off. Others are very, very closely involved in the management of the process. So before we get into detail, Brenda, can you tell us at a high level, give us a quick overview of the process at Seagate?
Sure. So here at Seagate, all of the correspondence and documents related to applications are managed within the database. So we'll go into detail later about the process the paralegals take when reporting out. But once the case is reported out, we ask that our outside counsel provide a search and strategy memo within a week. And that memo must be uploaded to our system and a message sent within the system to the handling attorney for review. Then we give them about a couple months, about 2, to prepare the first draft, and we ask for filing within about 100 days. And all of the documents are uploaded into the system, so they're readily available to anyone in the IP department to review, and messages are saved there as well, so we can track when drafts are received and when comments are sent back.
Okay, thank you, Brenda. And it sounds like one of the things that may be important to Seagate, and you said it in one of your last sentences there, is that everything be readily accessible to the in-house team. And is that one of the objectives or reasons why everything's done through your internal database?
Yes, definitely. We want everyone to be able to access application drafts, including the inventors. It's also important from a security standpoint. We require that everything be sent through Foundation IP, just so that everything is tracked internally and things aren't sent outside of the company before they're filed.
Okay, so it sounds like access and security are two big objectives that define or help to define what your drafting and filing process is.
Yes.
John, can you give us, have you experienced anything different? Is there a high-level process you've seen that differs from what Seagate's is?
It sounds fairly similar because the general principles are the same of giving the outside counsel a defined time to get things turned around and being able to have a common place to go to track with the client or with the firm. So not really, nothing different.
Okay, and then some of the high level objectives sounds again like common access for people within the department and a defined time to file, right?
Yes.
Okay, good. Let's get into a little bit more detail now. First, what I'll call the front end of the process, or the initial steps of assigning and distributing disclosures to outside counsel, can be a very involved task, particularly if you're one of the individuals in the category of having a portfolio with 500 or more applications a year. But any number of applications, this can be an involved process to make sure that it's done correctly. Brenda, can you explain how Seagate handles this? I know you have been very closely involved with improvements to this process recently, and would love to hear about what you guys are doing.
Sure. So once a patent review committee reviews and decides to pursue a patent idea, that the paralegal responsible must go into the system, and previously there were probably 5 or 6 different tasks that each paralegal had to do for each disclosure that was marked as pursue. So recently we went through and automated 3 of those steps just to alleviate some of the heavy workload burden. The things that we were initially responsible for doing were adding all of the responsible personnel to the matter in the system so that the internal Seagate people, the inventors, and our outside counsel had access to the correct matters, sending a message to the inventors informing them that their idea has been marked as pursue and what their next steps are, sending the actual instructions to outside counsel to prepare the application, updating the status of the record, confirming what we call classifications, technical classifications of where that application or that idea will fall, and then requesting dispensation or foreign filing licenses depending on where the inventors are located. So all of those steps would take a lot of time. So what we were able to do to streamline the process is automate some of the activities within Foundation IP in order to alleviate some of those. So we were able to, just by adding an activity that we call pursue, it will automatically send a standard email to all of the inventors informing them that their idea is proceeding and that they will be contacted by outside counsel. We are able to pull in the firm name, the outside counsel paralegal, and their email address so they know where it's coming from, where the correspondence will be coming from. And we ask them to provide their residency and citizenship information to our outside counsel so that it's all done within the system and we don't have to send a separate message requesting that information. The second part we automated was the instructions to outside counsel. It will pull in all of the relevant details, the title, our reference number, any dates specifically that we need, and then it has a space for special instructions. So when we create the activity, we have a space where we can add a note that maybe we want outside counsel to refer to a previously filed application or an already granted patent to review before they file. We did this because the message, the way that it's set up, it's automatic. It will send as soon as you click save on the activity. So there isn't a way to, set new instructions or clarify certain things. So we have a space where we can add special notes that will go to outside counsel. And from there, in that message, we ask them to provide us a list of the responsible people who will be working on that case, the responsible attorney, paralegals, anyone who needs access to that matter specifically in Foundation IP. And then the last part that we automated was changing the status. So within the system, we're able to trigger just by launching this activity and saving it, it will change the status automatically to pursue. And as a helpful hint, we also were able to implement that in some of our other decisions. So if a invention disclosure is marked as non-pursue or a trade secret, a similar process will follow where you'll docket the correct activity, and that will either send a message if needed or change the status to whichever the appropriate status of that disclosure would be. So all of those automations have really helped to streamline the process, and we're able to chug through our decisions much more quickly. And I think those were the high points. Anne, did I miss anything?
No, Brenda, that was great, and it really just emphasized how many tasks are involved just in this, what would seem like a simple step of assigning and distributing disclosures. So I think that's pretty interesting that if I heard you correctly, with a single activity that you've created, so this is a custom activity in Foundation IP, and you've just labeled it Pursue, you're able to automate about half a dozen different tasks that previously somebody was having to do manually. Is that correct?
Yes, and we did run into a couple pitfalls that I should probably mention. We had to update our internal procedures so that we were adding the relevant people to the matter before we added the activity. Otherwise, it won't pull in important information like the outside counsel and responsible attorneys and paralegals. And we also learned sort of the hard way that if you don't specifically identify the correct status label you want to change the status to, it has to be spelled exactly the same, any punctuation has to be exactly the same, that if you don't get those just right, it doesn't work. So a helpful hint to any of those FIP users out there to make sure that you identify your statuses and personnel first before trying to do any of these automated processes.
Those are great tips. And I imagine this has freed up a lot of time from the paralegals. Were the paralegals the ones who were responsible for doing these steps manually before?
Yes, so each of our paralegals is responsible for several technical groups or patent review committees, and then they have to docket and process all of the decisions for each group. So it can be sort of burdensome when we have a lot of disclosures depending on the time of the year or if we've had some harvest. So we like to try to streamline the process as much as possible.
So even if you're in a smaller organization and there's only one paralegal and maybe not as many filings as Seagate does, still being able to save time for that one paralegal with some type of automation like this would be a great process improvement. And although this is specific to Foundation IP, in my experience, many of the major IP docketing systems that are out there have some type of capability where you can create templates that will launch certain things or workflows that will initiate automation. So I think that there are some ideas here that can be taken and applied in a number of different contexts. That's very good. Thank you very much, Brenda.
Sure.
Okay, moving on to what I call the middle of the process. This is the tracking of the status of the applications. Just curious, Brenda and John, was there a lot of tracking of the pre-filing process tasks like scheduling a disclosure meeting or conducting the disclosure meeting? Did either of you work in organizations that track things at that level, or was it just the higher level filing dates, maybe draft dates, things like that? I'll start with Brenda.
What I mentioned earlier, we don't track it too heavily. We ask that we get a search and strategy memo within a week, and we docket that date when it's received. But we don't necessarily micromanage the firms too much on those dates. What we're more concerned about is the end filing date.
Okay. How about you, John?
Yeah, I have a similar answer. The end filing date matters, and most of the details are, from my point of view, are left to the attorney, the portfolio manager in-house. And just to give a plug for the paralegals, they are a critical part of helping the portfolio manager keep on track and kind of going behind the portfolio manager and cleaning up their mistakes and gently educating them. So both the paralegal and the portfolio manager have critical tasks, and paralegal can help the portfolio manager improve.
Great. Well, I've seen a lot of different companies' processes, and many of them are similar to what the two of you have described, but I've also seen and worked with a few companies that I'd say are on the opposite end of the scale. Brenda, you used the term micromanage in the context that you said Seagate doesn't micromanage. There are corporations out there that I think you could use that term to describe what they do, that they very much micromanage the outside law firm's process. And not that that's a bad thing, just it's a different process, and I want to share some of what I've seen. I've worked with a couple of companies that have very detailed tracking of the pre-filing steps in the company's docketing system, even though it's the law firm that's the one that's responsible. So some of the tasks for outside counsel that I've seen the company tracking and monitoring for metrics purposes are whether or not an invention disclosure meeting was scheduled, when that invention disclosure meeting has been scheduled, has it been completed, so a date for completion. Then sometimes there's a requirement to send a summary to the company of things that came out of that disclosure meeting, and that might be a date that the company's docketing and tracking to make sure outside counsel hits that deadline. Summaries might include things like confirming that there's no bar dates after talking to the inventors, confirming that the target filing date is accomplishable, confirming the inventors that were listed on the disclosure are the correct inventors, determining whether or not a foreign filing license is going to be required, even providing dates of conception, reduction to practice, or any planned disclosures, and even confirming if there are any issues with foreign filing rights not being available. So those are some things that I've seen companies require outside counsel to provide, and then they set a deadline and track whether the outside counsel has met that deadline. Then there's the more typical first draft due deadline, final draft due deadline, filing deadline, target filing dates, things like that. And in the instances where I've seen this very heavily managed by companies, the companies are actually tracking dates in their docketing system for these things, like docket deadlines, even though they're internal deadlines. The one system I've seen it done in quite detail is Anaqua Enterprise, but it's not the only one. That's just one I've seen lately. In each of those instances, then, one, the company has to have somebody that's updating the docketing system to indicate when those things have been completed, and the law firm has to have a process to send a notification to the company to let them know when they've completed each of those steps in the process. One thing that I find really interesting about my role at Black Hills is just looking at different processes. When I look at these more detailed corporate processes, I think these are particularly interesting because the types of dates in my example here that these companies are tracking are dates that usually I would expect the law firm to be tracking. The law firm paralegal, for example, is probably tracking the first draft due date, the target filing date, things like that. Now, in this instance, both the law firm's tracking that date and the company is tracking that date. And then, do you have duplication of resources now? Is that necessary? These are all process questions. It's not right or it's wrong. It's different approaches to the process. I think potentially some of the advantages of a more detailed process like this could be that obviously the company gets more detailed metrics for tracking and measuring the performance of their outside counsel. They also know that they're going to get the information in their docketing system very early on and have it be complete with respect to inventors, critical dates, things like that. And outside counsel is certainly not going to forget anything when it's all prescribed for them like this. From the corporate point of view, though, I think the downside to this approach would be the amount of resources needed to monitor the communications, update the docketing system, and keep it up to date so that you can run reports in-house and get the benefit of the fact that you are tracking these deadlines. That, for a larger portfolio, could take quite a bit of resources. So there's different approaches to how involved the company can be when it comes to tracking the dates. Now let's talk about the quality review for outside counsel's work that may be performed by the company's internal team. John, can you talk about how you've seen this handled?
Yes, okay. And I'd like to start with the third bullet point, who is responsible. And that is the in-house counsel patent attorney. It's all on them. Now, they have lots of help and they have lots of people who are responsible for subtasks. But to get a quality patent application filed, it's all on the attorney. So that's the easiest answer with the hardest task. I'd like to talk about what tasks are performed. And if I may use an animal husbandry metaphor, just think of a patent application as a creature that you're nurturing in the nursery, and you want to get a nice healthy beast and send it on its way for a great useful lifetime. So just some overviews of quality review philosophy. are, I encourage portfolio managers to look for three things. First of all, I'd say look for a brain and a backbone in this patent application. And what that is you review the invention disclosure form, and that's kind of the brain. And make sure when you go immediately to the claims, and make sure the independent claims have covered what is in the invention disclosure form. That's kind of the backbone. And then as soon as you've read the independent claims, find the exact language in the specification so that there's no question that this creature has a brain, a backbone, and so appendages that attach from the backbone. That's the first thing. The second one is remove any warts, and that's an expression we hear a lot of time. And that's basically just staying current on patent law. If there's a devastating decision that comes out from the Federal Circuit, you want to update maybe your quality review form to reflect that. And the other part of removing warts is when you're reading through a patent application, although it gives your patent attorneys a lot of leeway for creativity, but remove obvious mistakes bad grammar, missing reference numbers are mismatched. The third one is you want to enable a robust intellectual DNA for this creature that you're generating. And that is two things. The in-house counsel and should tell outside counsel what are the client's needs and their trends. And pardon the expression to use, but buzzwords matter if your senior management in your corporation is talking about things, or the senior engineers, the principal engineers, that you take those concepts and see if you can reflect them in a nice, natural way in the patent application, because later on, those things may be the most important elements in your patent application. And the other thing is allow the patent attorney the freedom to use their own creativity and style, because this creates a robust DNA for the patent application. And if you have several outside firms, let them operate freely inside that realm of creativity. So that's a healthy beast. And I want to talk about four other areas. The process of getting this healthy creature on its way to the patent office, and then some of the details of the pedigree, and then what are the reviewing attorney's duties, and then feedback. So the next one is the process. And the critical thing with the process is to give everyone enough time involved to get their tasks done. I remember an expression from one of my law school professors: the quickest way to get disbarred is practicing law in haste and for your relatives. So this one is practicing in haste. So give everyone clearly defined time periods within which they can operate, and then give clear deadlines and be sure to follow up. Then onto the pedigree. This is really where the paralegal helps. And on a quality review form, there are things that we want to make sure the paralegal gets checked, that the patent attorney has got everything right. And so this is where the paralegal really helps. And this is on the patent application, its title, and the client reference, the attorney, the firm reference. Just verify the inventors, and then the place and manner of filing, whether it's PCT or things like that, or where it was invented. And the important thing here is there are some jurisdictions that even have criminal sanctions if you get inventorship wrong. So we want to make sure we get that absolutely right. And then we check on priority, and then who's the working attorney and who's the reviewing attorney. And that, as the paralegal can really drill down on that and make sure that is all correct. And as was mentioned, we can, a lot of that data can be entered and it goes into the database, or it can be populated from the database into a quality review form. Okay, now onto the details that the reviewing attorney does. It's kind of like in a dog show competition. The judges are looking for specific marks of the breed, if they're signs and forms and everything. And this gets into the preliminary considerations of inventorship, whereas the paralegal on the pedigree chart may just list the inventors. We want to make sure that inventorship, if it changed, that it was reflected that it was changed. And then onto claims, and this is an important part. If you have an international practice, there's probably a short list of jurisdictions that your employer or your client is filing in. And so you want to perhaps generate a global claim set at the beginning, that maybe there's a handful of jurisdictions. You draft them for each one tailored to those jurisdictions, so that even if you're not filing PCT initially, you can have them there while all that information is fresh in the drafting attorney's mind. And then of course you want to cover everything as best you can, going back to the invention disclosure form, and then maybe pressing some of the boundaries of what needs to be taught and claimed. Then the other things are like I said, removing any warts. Some firms prefer a background. Some firms don't want, or clients don't want you to use a background. Same thing with a summary, and checking also for things like copyrighted and trademark material. Onto the claims. One of the critical things is the issue of divided infringement. And when you're reviewing the claims, maybe clear up at the front of this process, you look at making sure that you can target a single alleged infringer. And so there are ways to do that where you can compound two elements of a claim into a single element, and that eliminates a supplier. And obviously there are the detectability issues, and then you get down into whether you're in software, you're in biotech, and there are several area-specific practices that are required there. So once you get through all of that, then there's the feedback issue, and it was mentioned there's timeliness. I like to call it aging. If a patent application it comes back within that timeline, that's very fine. If it gets a little bit late, that's not wonderful, but it's still okay. And it's medium late, you want to give them feedback. And if it's extremely late, you might want to have those color coded. That's how I did it, just to quickly see a spreadsheet and see how everyone is doing, and then listing the individual attorney and the firm. And then you can keep in feedback. You can keep a short list of your needs improvement attorneys, even a short list of your needs improvement firms. And obviously, we tend to notice just when things are not going as well. But you also keep a short list of your good firms and maybe the stars at the firms that are doing your work for you. So anyway, the one of the systems that can be used, like I said, is a spreadsheet. Although I don't recommend putting process comments into the spreadsheet, because even though it's probably a privileged communication, you don't want to have that somehow lose the privilege, and you may have some process comments that are tumble out into a possible litigation. So that's pretty much a summary of quality review. Okay.
Great, thanks, John. again, what seems like a simple step, do a quality review of outside counsel's work. That's amazing how many tasks there can be involved in doing that. So thank you very much for sharing that and giving those tips. I particularly like the one about telling outside counsel what's important to in-house counsel, so that they know what you want. Because you're right, different companies have different preferences, and from a company's point of view, if you tell them what you want, you got a much better chance of getting back what you're looking for. So that was a great tip, but there were some great tips in there.
Yeah, and I wanted to comment on that. If you're outside counsel and you have a big client, and you can go to their websites and see their news releases and keep up on that, because otherwise you are kind of stuck in a back room at your law firm drafting patent applications. And if you go see their news releases and their websites and ask the attorney that's in-house who's managing you what's going on maybe inside their own little their world inside a bigger company, then you can perhaps get a more genetically robust patent application drafted for them.
Good tip. Brenda, I'm curious, do the attorneys at Seagate do a quality review of outside counsel's applications prior to filing?
Sort of. Again, we like to see that search and strategy memo at the beginning, which kind of the in-house attorneys will review to make sure that outside counsel is pointed and focused in the right direction with their first claim, at least. Once the application is approved by the inventors, we require that our outside counsel provide it to the in-house attorney for final review. But if the in-house attorney does not reply within a week, they're authorized to go ahead and file. I wanted to mention two quick little things about sort of the stage of unfiled applications, if I may. Each of our attorneys receives a report monthly of all of the cases assigned to them which are unfiled, so that's kind of how they can further track their cases, and some are more hands-on in that than others. Some of them just rely on outside counsel to follow up, and others really manage that spreadsheet to find out the status of those cases. And then we also have reports that run monthly that send to our outside counsel that list all of the unfiled cases that are assigned to them, so that they can confirm that what we show in our record is accurate with what they reflect in their docket. And this has been helpful because we've had cases where outside counsel has spoken to the inventors and they've decided not to proceed, but that instruction doesn't always make it back to the paralegal responsible for docketing that case. So having those reports sent automatically monthly has really helped streamline to make sure that exactly what's unfiled, marked as unfiled in our system, is actually unfiled, and the cases that are filed are confirmed filed and updated accordingly.
Well, that's interesting. I would assume it's fairly common, and certainly in the organizations I've worked with, it's fairly common for companies to run aging reports. John, you used the term aging, on unfiled applications and look at them internally. But I think it's interesting, Brenda, your additional step that you guys take to send that report to outside counsel as well, so that they can proactively clean things up and address things, rather than probably having a paralegal take a lot of time to follow up and say, hey, what's the status of this application? What's the status of that application? So another good example of how you can make things more efficient through your processes. Thanks for sharing that one.
Sure.
All right. We have discussed how corporate IP departments assign and distribute disclosures to outside counsel, how they track the status of applications, and how they perform quality reviews. The approaches range from very little tracking and management of outside counsel's process to what some might consider to be micromanaging outside counsel's drafting and filing process. There really is no right or wrong answer here. As I said in the beginning, the right process is the one that best addresses the needs and the objectives of the particular company. And I'd say regardless of the size of the company, or regardless of which side of the scale you're on, hands-off or very involved, it's important for the company to have clear procedures and checklists for the processes that are going to be applied, whether it's checklists for the paralegals on the setting up and distribution of new disclosures, or whether it's checklists for the attorneys who are doing the quality review, or any other step of the process. And wherever possible, you can really be more efficient and more reliable if you can identify aspects of your process that you can automate the way, for example, Brenda's given us a couple examples of the FIT Pursue activity that they created and the amount of manual steps that were eliminated through just that automation. So I'm hoping that as a result of this program, we've at least got you thinking about things. Maybe you're thinking about ways that you might be able to change your process internally. Maybe there's a task or something we talked about today that you want to add to your internal process. Or maybe you got some ideas today about how to better track the outside counsel's filing process, whether you're doing that through manually keeping track of things or automating tasks to keep track of and manage the process. Or maybe even you've thought a little bit about now who's the right person to be responsible for a particular step in the process. As John pointed out, there's certain things that the attorneys own. There's other things that the paralegals are responsible for. I think the most important thing to a successful process is getting the right person in the right role in the process, or where it doesn't even have to be a person, automating that step of the process. So hopefully those have given you some things to think about. If you're looking for additional input or ideas as you analyze your own internal operations, I recommend joining Black Hills IP's Docketing Excellence group on LinkedIn. We started this group a while back. There are nearly 500 IP professionals in this group. It's a place where you can post comments and hopefully somebody in the group, now that it's gotten to a very decent size, maybe addressing the same issue or problem, and we'll get back to you with some comments or suggestions. So I only mention it as another resource that's out there as you go through and look at your processes internally. If you're not already a member of this group, you can join by going to the Docketing Excellence website, www.docketingexcellence.com, and then there's a heading for the LinkedIn group and a button for Join Today. And it's very easy to join that group. And really want that to become a forum that's a resource for IP professionals to connect with other people on docketing and operations type questions. So I want to remind the audience that if you have questions on today's program, those can be submitted through the questions box on your screen. And I'm going to take a look here to see if we have any questions. Hold on. Looks like we have a few. 1 second. And then while I'm getting this set up, if you have any questions about Black Hills IP's services or processes, please contact our Vice President of Sales, Jim Brophy, and his contact information is listed on the slide there for you. So let me take a look at the questions we have. Okay. So Brenda, this one goes to you on the automation. And the question is, was the automation implemented through Foundation IP, or was it done by using IT resources? Did you guys go through CPA Global to do it? Did your IT department do it? Did you have to figure it out? Who implemented that automation for the Pursue activity that you talked about?
So the Pursue activity and all of our updated invention disclosure decision activities were all done by me with the help of some SIP friends that I know who have a lot more experience than I do and some tips and tricks. But it wasn't especially difficult to do it myself. There are resources in the SIP Wiki on how to do those things. I'd also be more than happy to speak to anyone who needs help about how to implement those. I also highly recommend that before you make any changes in production, you create and test all of the activities and staging. One, because you want to make sure the messages send, but you're not sending actual messages, and two, to make sure that your statuses actually update to the correct statuses and that things work as they're supposed to. But I didn't need any IT support, and I didn't contact CPA. We did it all internally.
Great. Okay, let me see. I got a couple more in here. John, this is really for both of you, but I'm going to direct it to John first. Do any of the speakers have insight into whether there is a trend in corporate clients performing less review on outside counsel's work product? John, you're in private practice now, so have you seen companies moving away from that detailed QR process?
No, I don't have enough information to say I see a trend, but I could comment on in-house counsel's trust of outside counsel's past performances, where you could have different levels of review, and down to the level of called an audit, right, where you may just do a very cursory review of someone who is a well-traveled, well-seasoned, and trusted outside counsel, to not quite micromanaging, but some new attorney that's joined a firm, and you really want to read their patent applications extremely closely so that you can help them and also train them. It's not just on the outside counsel managing partner for that case, that you can work together, and that way you create a nice relationship with the new kids who have just come to work. So, and there's a whole spectrum between there.
Good. Sean, I'm going to direct another one to you, although I don't know that you're going to have the answer to this. What are typical legal costs now to prepare and prosecute a nominal 30-page patent application with 25 claims? I would say that varies greatly depending on technology, depending on the priority level of the application. I couldn't say what a typical cost is, but John, do you have any thoughts on that?
No, I couldn't say either. Your answer.
That one varies widely. Okay, this is a follow-up on the review question. So, less review is more so related to prosecution. I think it might be even more of a comment. Less review is more so related to prosecution rather than drafting. So, again, would you say that it's fair that there are less companies reviewing the prosecution as opposed to the original drafting of the application?
And that's directed to me. I don't have an up-to-date survey on that, but my own experience was when I came out of law school and started working on prosecution, there was an attorney at another firm who had the same client who reviewed my prosecution work until he certified to the client that my prosecution was competent. And I'm happy to say it was very quick because I had just come from the patent office. So I still think it's good practice to review at least annually the prosecution, a specific case, to make sure that your outside counsel is carefully watching over your patent application.
Good. How does an outside counsel charge for QR, time and billing or fixed cost? This might be something we need to clarify. That QR process that you described, John, was done by in-house counsel. The only place where I think it would impact fees is if in-house counsel says, I need you to revise this, I need you to make further changes. then there's going to be more time by outside counsel. But the question was, how does outside counsel charge for QR? And I think that's just a confusion on what we were saying. Anything else on that, John?
No, you can give a fixed fee, or you could give a fixed fee with exceptions where the reviewing attorney needs more time. And like I just said, I was QR'd on my prosecution by outside counsel when I was outside counsel at another firm. So the task of doing QRs can be either inside or by outside counsel.
Okay, good. Then thanks for clarifying that. I think we'll take one last question as we're getting close to the end of the time here. Is there docketing management software to help small firms track and to work with you? So I think what this question is getting at is, Foundation IP, Anaqua, some of the systems that we mentioned are probably more expensive and maybe more complicated, or not complicated, but maybe have more features than what some smaller firms may need. Are there other options out there for docketing systems that firms might consider? The one that I can throw out there, and this is by no means a plug, there's multiple systems out there, but one that I've seen used by a lot of smaller organizations is a system called AppCall, AppColl. It's a system that's got the basics of what you need, even can be used by a corporation because it does have a invention disclosure submission module to it as a possibility, but it certainly has the docketing functions in it as well. It's a pretty simple interface, easy to use, and fairly reasonably priced. There are others out there, and I'm by, again, no means plugging AppColl, other than it's one that I'm seeing more and more used by smaller organizations. John or Brenda, are there any others that you've seen? Or have you just more experience with the bigger systems?
Bigger systems.
Yeah, me as well. I think that at least in my work life, it's been mostly focused around Foundation IP and Anaqua, LaCorpio, the big ones.
Yeah. Yep, that's what I think too. So, all right, well, we're right up at an hour. I want to, let me go back to my slides here, get rid of these questions. So I just want to let everybody know that the next webinar in this series is in January. It's on the 17th of January at 1 p.m. It will focus on best practices and processes for managing non-final office actions and responses. Also, just to let you know, if you have previously listened to some of our docketing webinars, we've been haven't had any for a couple of months, but we'll be resuming the Docketing Excellence webinars early next year. I'm just about done defining a series of monthly trademark docketing webinars that will go for 6 or 7 months starting in early January. The registration information for the trademark docketing webinars should be on the Black Hills IP website by the end of December. So watch for that under the Educational Resources menu. And then we also have a webinar series on foreign prosecution. This is more directed to attorneys, but does not have to be. It's called our Foreign Excellence series, and it takes an in-depth look at the patent process in different foreign countries, including the scope of protection available, enforcement, filing basics, prosecution basics, etc. The third program in that webinar series is tomorrow at 1 p.m. Central, and we'll discuss the process for patenting in Korea. I have 2 Korean patent attorneys who will be sharing their insights on the process in Korea, as well as the former chief patent counsel from Micron, who will share some filing strategies for companies with larger portfolios and how they took Korea into account. So you could register for this program still, and that is also through the Educational Resources tab under the Foreign Excellence series on our website. So lots of free resources available. I hope you can take advantage of them. Thank you for participating today. We hope you will join us for some of these future webinars in our series. Thank you very much. Goodbye.